So this is the financial focus portion of this webinar. And today we're going to talk about a federal court ruling where an ex-girlfriend of someone who passed away, an ex-girlfriend from 25 years ago, was awarded $1.15 million after this person passed, surpassing not only his current live-in girlfriend, but his estate. And we're going to get into the hows and whys, but again, this is the the financial focus portion of this webinar. If you want to listen to the other portion of the webinar, you can. But let's talk about this here. So I'm going to share with you the documents here. So let me make an adjustment. I want to be drawing this a little bit. So I'm going to share with you the documents. So this is from the fall of last year, and this is from one of the Ed Slott updates. So I'm part of the Master Lead Advisor group for Ed Slott. This group has been involved with Ed. Ed's been a resource and mentor of mine since for many years. I've sat on his board, his advisory board, and I just can't, you've heard me gush about this. I can't say enough about it. And like I said, one of my favorite things during our updates, our semi-annual updates, is our tax law updates. So this is an example. So this is directly from the manual that I'm sharing with you. But you can see here the latest IRA tax law changes, new strategies, rulings, etc. Again, I never miss this section. And here we are. This ex-girlfriend from 25 years ago awarded $1.5 million after the death of a participant who never changed his beneficiary designation. And it's the Rollins case. And this is from April 29th, 2024. So I don't remember why, but I was going through the manual and I saw this and I thought, my goodness, I've got to share this with y'all because it really drives home the importance of updating your beneficiary designations. So ex-girlfriend from 25 years ago awarded $1.15 million after the death of participant who never changed beneficiary designation. And here's just a summary here. So I'm right here. A Pennsylvania federal court found that an individual's 1987 designation of his then girlfriend as sole beneficiary of two Procter & Gamble retirement plans was still valid following his 2015 death. Even though the couple broke up in 1989, in 2020, the court awarded the $1.15 million total account balance to the former girlfriend because it found that the participant had not taken any steps to change his beneficiary, despite receiving repeated notifications from the plans of his ability to do so. So the plan told him, "Hey, update your beneficiaries." It's part of the court decision was, did Procter & Gamble follow their fiduciary responsibility? Now, as a plan provider, they have an enormous responsibility. And I'll just tell you, the court found that they did because they notified him. They notified him that he should review and update his beneficiary designations. In this 2020, so I'm right here now. In this 2024 decision, the court rejected a claim by the decedent's state, that the plans breached their financial fiduciary duty to provide adequate information about his beneficiary designation. The court also rejected the estate's claim that the ex-girlfriend was unjustly enriched by the award of the benefit to her because the beneficiary designation was a mistake. So they took a couple different swings at this. So here are the facts. And these are public records, so I'm not disclosing anything, because the person's name is in here, whatnot, but this is all public record. So Jeffrey Rollison was an employee with Procter & Gamble for over 28 years when he died on December 14th, 2015. Now, pay attention to that. We're talking about a case from 2015. It's 2025. This is still going on. Think of the time and the expense that's wasted on this. But Jeffrey was unmarried at his death. Rollison was a participant in the Procter & Gamble Profit Sharing Trust and ESOP. That's an employee stock option or stock benefit plan. And the Procter & Gamble Savings Plan, and had accumulated a total of $754,000 between both plans at his death. Both plan documents provided that upon a participant's death, his account balance is to be distributed to his beneficiary. The document also said that in the absence of a named beneficiary, the benefits of an unmarried participant are to be paid to the participant's estate. On April 27th, 1987, Rollison filled out and signed a 3x5 card that served as the plan's official beneficiary form. He designated Margaret, I'm not going to try, I don't know how to pronounce her last name, but Margaret M. Stostedt, as his beneficiary, now known as Margaret Lossinger, and as his sole beneficiary of both plans. Lossinger was Rollison's girlfriend and cohabitant at the time. Rollison and Lossinger ended their relationship in 1989, but Rollison never changed his beneficiary designation. Rollison never changed his beneficiary designations. On numerous occasions throughout his employment and as recently as 2015, Procter & Gamble sent notifications to Rollison suggesting that he review his beneficiary designation and advising him that he could change his designation at any time. Procter & Gamble also sent Rollison information about the company's transition to an online beneficiary designation system, which started as an option in 2007, before fully transitioning online in 2015. These notifications made clear that Rollison did not, if Rollison did not designate an online beneficiary, the beneficiary he designated on the paper beneficiary form would receive his Procter & Gamble plan benefits. Rollison logged into his online beneficiary account 3 times just prior to his death, but never made an online beneficiary designation. So we're here. Let's come back to here. But Rollison logged into his online beneficiary account 3 times just prior to his death, but never made an online beneficiary designation. So 3 parties, Rollison's estate, Margaret Lossinger, and Mary Lou Murray, Rollison's most recent girlfriend, stepped forward to assert their claim to Rollison's benefit under the Procter & Gamble plan. The estate based its claim on the disputed allegation that Rollison was unaware of his decades-old designation and therefore believed he had no named beneficiary. Under the plan's provision, the absence of a beneficiary designation by an unnamed participant would result in the estate becoming the beneficiary. Lossinger based her claim on the designation as beneficiary on the paper beneficiary form, which Rollison never changed or updated prior to his death. So the estate says, listen, there really was no beneficiary here. You have to dismiss the 3x5 card. Then Lossinger says, you got to pay attention to the 3x5 card. That's what's ruling this beneficiary designation. And then Murray, the recent girlfriend, based her claim on her alleged status of the common law spouse as the common law spouse of Rollison, although she admitted that the relationship ended in 2015 before his death. In April 2017, P&G, Procter & Gamble, I'm just going to say P&G from now on, filed an interpleader action to determine who is the rightful beneficiary of the benefit. Interpleader is often used by a plan administrator when there are multiple claims to a plan benefit. By filing an interpleader, the administrator throws up its hands, and asks the court to decide who is entitled to the benefit. So they're getting 3 claims. So you've got old girlfriend, estate, most recent girlfriend, who says they had a common law marriage. The plan says, we're not deciding this one. Let's send it to court. In a July 2020 decision. So here we go. So now we're 5 years into this already. In a July 2021 decision, the United States District Court for the Middle District of Pennsylvania directed the plans to award the disputed funds to Lossinger. Whoa. By 2020, the account had grown to $1.15 million. In the 2020 decision, the court first noted that the P&G plans are ERISA plans. So ERISA is a law from 1974, and it's the Employee Retirement Income Security Act. Employee Retirement Income Security Act. Yes, that's right. That's right. And of 1974. I think it was 1970. Yes, it was 1974. It doesn't matter. But ERISA establishes many things, but a fiduciary responsibility of the plan sponsor. And you hear about fiduciary responsibility, and a lot of times that standard is referred back to ERISA, because ERISA is considered the gold standard for fiduciary responsibility. So under ERISA, the fiduciary shall administer the plan. We're here under ERISA. The fiduciary shall administer the plan in accordance with the documents and instruments governing the plan, making payments to a beneficiary who is designated by a participant or by the terms of the plan. However, ERISA has no provision telling a plan administrator how to determine the proper plan beneficiary in the face of multiple claims. Again, we have 3 claims. Therefore, when faced with competing claims, applicable state law determines whether a beneficiary has been changed. In Pennsylvania, the rule is that an insurance policy holder or plan participant is not considered to have changed the beneficiary unless he has been in substantial compliance with the policy or the plan's procedure for making that change. Now, these 2 paragraphs we can skip because it's talking about the definition of substantial compliance and reasonable effort, and give some case law you can see here establishing that. But again, I love this stuff, but in the interest of time, we'll just move forward. So we'll pick up here. The court found that Rollison did not take any positive, unequivocal steps or make every reasonable effort to change his beneficiary. Therefore, he had not been in substantial compliance with the P&G plan rules for changing beneficiaries, and Lossinger was his rightful beneficiary. The court went on to find that Murray presented no evidence to support her claim that she had common law marriage with Rollison that would have entitled her to the benefit. So now Murray's out, right? So, the court found that she has no claim because she hasn't even established common law marriage. Continuing with the long procedural history of this case, P&G, Rollison's estate, and Lossinger each subsequently filed motions and cross motions challenging the 2020 decision. Murray was dismissed from the case because she did not take any steps to pursue her claim. Because again, they established no common law marriage. What standing does she have? You used to be a girlfriend. The older used to be a girlfriend, at least says Lossinger. I've got my name on a 3x5 card, or an index card. The court decision. The estate first argued that Procter & Gamble violated its fiduciary duty under ERISA to disclose material information to Rollison. Specifically, the estate contended that Procter & Gamble should have provided Rollison with specific information regarding his designated beneficiary instead of just generic information. Generic information being, make sure you update your beneficiary form. Here's how to do it online. Here's how to do it by form. And then I think it was in 2015, it all became online. Procter & Gamble refuted this contention, arguing that it had fulfilled its disclosure requirements by consistently and adequately informing Rollison about the status of his beneficiary designation and how to change it. The court agreed with Procter & Gamble. To succeed on a breach of fiduciary duty claim under ERISA, the estate would have to show that 1, Procter & Gamble was acting in a fiduciary capacity. 2, Procter & Gamble failed to adequately inform Rollison of his beneficiary designation. And 3, Procter & Gamble knew of the confusion generated by its silence. And 4, Rollison relied on the misrepresentation to his detriment. Clearly, Procter & Gamble was acting in a fiduciary capacity, the first element. However, the court ruled that Rollison's estate failed to satisfy the second and third elements. So now, there's some statements from the court that, again, we can skip due to time, but we'll go to here. But you can, if you want this document, if you're really that interested, I can send it to you, or you can look it up. It's not going to have some of the information from the Slott group, but again, it's a public document. So the court added that the estate also failed to establish detrimental reliance by Rollison, the fourth element of its claim. To establish this element, the plaintiff must have reasonably taken some action or refrained from taking certain actions regarding benefits or retirement as a result of the misrepresentation. However, there was no evidence supporting the estate's position that Rollison failed to change his beneficiary status because of any misrepresentation or omission by Procter & Gamble. So the estate went on to argue that the court should establish a constructive trust on behalf of the estate that would require Lossinger to turn over the estate the funds previously awarded her. Under Pennsylvania law, however, a constructive trust arises where a person holding title to property is subject to an equitable duty to convey it to another on the grounds that he would be unjustly enriched if he were permitted to retain it. The court found that whether Lossinger had been unjustly enriched by the distribution of the plan's funds to her required the estate to show by clear, direct, precise, and convincing evidence that Rollison's continued designation of her as beneficiary is a mistake. According to the court, the estate did not satisfy this burden. So again, if you want to read this from the court, it's actually the opinion that's issued by the court. But the court, coming down here, the court rejected both of the estates. I'm sorry, I'm covering it up. Therefore, the court rejected both of the estate's most recent arguments for overturning the 2020 decision awarding Rollison's benefit to Lossinger. The estate's attorney has said the estate will appeal. So this was April. This last bit was April 24. They're going to appeal. So it goes on. Wow. What a mess. It's a common mess. That's the problem. People get notifications about the beneficiary designations. You hear it over and over again. You certainly hear it on this channel. You hear it. You should update your beneficiary designations. You should review them every single year. You should keep copies of your beneficiary designations. We have beneficiary designations on file, but clients should have copies as well. Now, I'm going to share this with you. These are the advisor takeaways. So when we're presented with these cases, then I'm going to give you kind of a behind the scenes view of some of this training, and now we're just imagine we're in a big like auditorium or a hotel ballroom having these updates. There's a few hundred of us, and we go through this Rollison's case. So now we all know this, right? We all know, all of our people who have been doing this for a while anyway, that we should have beneficiary designations, that there's court cases going on like this all over the country all the time. And this is why it's so important to update these beneficiary designations. And Ed and his team put together, okay, here's the case. Here's the information about the case. Now, this is what you should be doing about it. Well, so the first thing is checking clients' beneficiary forms. Don't take that for granted. Too many people skip that. They just assume, including financial planners, financial advisors, we already know what that is. We did that last year. It's all good. Or they told us they have their beneficiary forms referring to the client. So all is in place. No, we want to make sure that that's correct. So let me just clear this up here because I want to read you this section here. This is important because this reads, clients often ignore beneficiary designations, or they believe someone else is taking care of it. And that's common too. Well, doesn't my plan take care of that? Or isn't my advisor taking care of that? Well, I hope your advisor is helping you take care of it, but it's ultimately your responsibility. So they believe someone else is taking care of it, or it's covered in the estate plan, or the will, or some other document, but it is not. Many clients do not realize the importance and long-term significance of their retirement account beneficiary forms and lose track of them. It is ironic that most people can locate their wills, but the will does not govern retirement accounts. Those funds pass outside the will by beneficiary designations. This has become, they go on to write, this has become an even more serious problem with all the recent financial institution mergers. So if you just stop and think about banks, wealth management firms, advisors changing, you can come up with a whole handful of mergers, acquisitions, and changes that are going on or have gone on in the past few years. In many cases, retirement account paperwork, I'm right here, if you're following along. In many cases, retirement account paperwork is either not brought over to the new firm or is carried over but not entered properly in the new firm's system. Often beneficiary forms are lost in the shuffle. Happens all the time. Ed's team goes on to say it's not necessary for advisors to waste time searching for missing beneficiary forms because you can just redo them. So new forms override old forms. If one was dated April 13th May, we're in May 13th, and the new one is dated May 14th, the new one wins, right? The updated one wins. So you don't have to go looking for the old ones. You should have the old ones, but if you don't have access to them, just do new forms. Existing beneficiary forms should be checked to make sure both primary and contingent beneficiaries are named. Naming a contingent is important in the case that the primary beneficiary predeceases the owner. There we go. That's important. It also facilitates post-death estate planning and disclaimer opportunities. So a disclaimer is when somebody says, I don't want this inheritance. So it actually happened to my mother. So my mother inherited, if you attend a class, you know the story. My mother inherited a retirement plan from my sister when she passed away. And it was very similar to this. My sister never changed her beneficiary designation, even though she had a terminal illness. So, so my mother was put in a very bad situation, and she disclaimed that, and then it went to her husband. But it didn't go to her husband because he was the next named beneficiary. That would be a contingent beneficiary. It just went to him because by law that he was the next person in line. But first of all, what should have happened is she should have named her husband as primary beneficiary and probably should have named her daughter as a contingent beneficiary, because then if the husband passed away, then the money would go directly to her daughter. So you want to name that contingent beneficiary. Or in the case that if he said, you know what, I don't need this money, I'm going to disclaim it, then it would directly go to the daughter or whomever you put down in your beneficiary form. When there are multiple beneficiaries, forms should also be checked to make sure that the name and share is clearly stated and that percentages add up to 100% or that fractional shares add up to 1. Because you don't want this confusion. You don't want a plan provider to throw up its hand and say, I'm not making this decision, send it to court. Because I think it's Rollison. Yeah, the Rollison case has been going on since 2015. It's 2025. It's not enough to keep IRA and plan beneficiary forms on file. Advisors should review these forms with clients at least annually or more often if changes due to life events, marriage, divorce, birth of a child, a grandchild, or new tax laws warrant it. Finally, you should make sure that client beneficiaries know to contact them. So know to contact your advisor after the client dies. That way, beneficiaries will not have to be concerned about where to locate the beneficiary forms or whether they exist. Default beneficiaries, it goes on to talk about. We can skip over that. Married retirement accounts, divorced retirement accounts. This is all really, really great stuff. And this is the type of guidance that we get on the from this group. And if your advisor is not associated with this group, you should change, or you should convince them to join, because it's just so important. It's important for you to stay educated. It's important for us to stay educated and up to date about things. I think you'd be hard pressed to find a good financial advisor that doesn't know the importance of updating beneficiary designation forms. But in practice, because many financial advisors have hundreds of clients that they manage, I think in practice it would be very hard for them to say, yes, this is something I make sure is done every single year. Of course, we, as part of our process, we have a checklist for our financial planning process, and we review beneficiary designations. It's typed out on our financial planning checklist every single year. We review beneficiary designations, and we make changes as needed. But these things are really important. So don't tie your family up in a 10-year plus court case, because you didn't take a simple step like change and update your beneficiary designation. So that's just one case, the Rollison case. I was excited to share that with you today. I hope you got some benefit from it. I hope you kind of saw, behind the scenes, what kind of updates we get and information we get and the steps we take to stay updated and stay on top of things and make sure that we're doing the best that we can for you. So that's the webinar for today, folks. If you're coming to the wine walk on Saturday, make sure you say hello. If not, we'll see you next week, and I hope you have a great weekend, and we'll talk to you soon. Take care.